Hello viewers, welcome to our channel Low Point once again. This is Anisha Babu. As we have seen, Muslim law derives itself from four sources which have been used to create rights for both Muslim men and women. These are Holy Quran, practice of the Prophet called Sunna, consensus of the learned man within the community called the Ijma, scientific deduction of right and just in accordance with good principles laid down by Allah called the Qiya. So today we are going to see what happens if a Muslim person dies without leaving behind a will. That is the rules of intestate succession for Muslims. We have a Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to talk about the same. So let's watch.
Inheritance of property in Muslims is governed by the Muslim Personal Law Shariat Application Act 1937. It is important to note herein that a Muslim person can give away only 1/3 of his property by way of a will, whereas remaining 2/3 of his property will be inherited by his legal heirs as per the Muslim Personal Law. When a Muslim person dies, his property will be utilized firstly for paying his funeral and burial expenses and then for paying his debts. Thereafter, his property is divided among his legal heirs. It is important to mention herein that there are two sects in Muslims, Shias and Sunnis. After the death of Prophet Muhammad, there was no successor to lead the Muslim community. Those who believe that a new leader should be chosen by consensus are called Sunnis, and those who believe that only the Prophet's descendants should be the successor are called Shias. In India, around 75 to 80% Muslims belong to Sunni sect and around 20 to 25% of Muslims belong to Shia sect. These two sects are in agreement on many aspects of Islam, but there are considerable disagreements between them. As per Sunni law, there are three types of heirs: sharers, residuaries and distant kindred. Whereas as per Shia law, there are only two kinds of heirs: sharers and residuaries. This is because Shia law includes members in distant kindred also under residuary class. Sharers are the ones who are entitled to a certain fixed share in the deceased property. These relations include primarily husband or wife, daughter and son, father and mother of the deceased. Whatever be the circumstances, these people will inherit a fixed share in deceased property for sure. There are other members also in the category of sharers. Let's see who these sharers are. They are
children of a son, that is, son's son and son's daughters. Then paternal grandparents. They are father's father, father's mother. Then comes full sister, full brother. Full blood siblings means they are siblings of the deceased from the same parents as that of the deceased. Consanguine brother, consanguine sister. Consanguine siblings have a paternal connection in common. That means deceased has the same father as that of his consanguine siblings, but their mothers are different. This happens when a father marries more than one time, wherein children from one wife are consanguine siblings to children from second wife. Uterine sister and uterine brother. Uterine siblings have a maternal connection in common. That means deceased has the same mother as that of his uterine siblings, but their fathers are different. This also happens when mother marries more than one time after divorce, wherein children from one husband are uterine siblings to children from second husband. But if husband or wife, daughter and son, father and mother of the deceased are alive, then the remaining sharers get shifted to residuary and distant kindred class. The rule is, closer the blood relations, higher is the preference given to it over others. For example, if father is alive when the deceased passes away, then paternal grandparents, full blood siblings of the deceased, consanguine siblings, uterine siblings do not get any share in the property inheritance because here, as compared to these relatives, father is the closest relative of the deceased. Similarly, full blood siblings get preference over consanguine siblings. However, they do not get preference over uterine siblings because Muslim law gives equal importance to uterine siblings as that of full blood siblings.
Next class is residuaries. They take up the shares in the property that is left over after the sharers have taken their part. Under Sunni law, they include the relatives wholly connected through males called agnate relatives.
We have already seen the sharers becomes residuaries also. This class of residuaries further divided into three categories. The first and most preferential category is that of descendants of deceased Muslims, such as son, daughter, son's son, son's daughter, etc. Second preference is given to ascendants of deceased Muslim, such as father of deceased, father's father, father's mother, etc. Third category within residuaries who are eligible to get property if there are no ascendants and descendants of deceased Muslim are called collaterals. They are again divided into two subdivisions. Collaterals of deceased Muslim such as full blood siblings, consanguine siblings, etc. Second is collaterals of father of the deceased Muslim such as father's full blood siblings, father's consanguine siblings, etc. Please note that the children of all the above said male relations are again covered under residuaries. For example, sons' children, full brothers' children, consanguine brothers' children, etc.
Next class is distant kindred. They are relatives wholly connected through females, called cognate relatives.
Here also similar three classifications. Descendants of deceased Muslim such as daughters' children, sons' daughters' children, etc. Secondly, ascendants of deceased Muslim such as deceased mother's father, mother's mother, etc. Third is collaterals, which are again divided into two subdivisions. First is collaterals of deceased Muslim such as uterine brother, uterine sister, etc. Second is collaterals of mother of deceased Muslim such as mother's full brother, mother's consanguine brother, etc. Please note that under residuaries class, if any daughter or sister is mentioned, their children comes under distant kindred class. For example, full blood sisters' children, consanguine sisters' children, sons' daughters' children comes under distant kindred class.
It is important to note herein that if a father has 3 sons and one son passes away before the father, then at the time of the father's death, if other 2 sons are alive, then the deceased son's children will not inherit share in deceased father's property. This is not the case under Christian Succession Law and Hindu Succession Act. There, even if a son has passed away before the father, and on the demise of the father, the deceased son's children will inherit the deceased father's property. How the property of the deceased is distributed between sharers, residuaries and distant kindred will be the topic of our next session.
Thank you for watching. Stay tuned till then. Take care. Bye-bye.